Welcome to EUPrivacyForAll Session52 on GDPR, Article 88, Processing in the Employment Context. Article 82 on the processing in the employment context was finally retitled Processing in the Context of Employment and is now Article 88. It stresses that Member States may, by law or by collective agreements, provide for more specific rules to ensure the protection of the rights and freedoms in respect of the processing of employees' personal data in the employment context. Moreover, those rules shall include suitable and specific measures to safeguard the data subject's human dignity, legitimate interests, and fundamental rights, notably regarding transparency of processing, the transfer of personal data, and monitoring systems at the workplace. Each Member State will have the obligation to notify to the Commission those specific provisions. Reminding the general rule set forth in Article 88, Recital 155 highlights the fact that those specific rules laid down in Member State law or collective agreements will have in particular to tackle the basis of the consent of the employee. Another key provision is Article 9 on the processing of special categories of personal data. In paragraph 2, it sets forth that paragraph 1 forbidding the processing of special categories of data shall not apply if processing is necessary for the purposes of carrying out the obligations and exercising specific rights of the controller or of the data subject in the field employment, insofar as it is authorized by union or member state law or by a collective agreement, and that appropriate safeguards for the fundamental rights and the interests of the data subject are provided. In Article 8 of the Directive 95/46, it is provided that forbidding the processing of special categories of data shall not apply where the processing is necessary for the purposes of carrying out the obligations and specific rights of the controller in the field of employment law, insofar as it is authorized by national law providing for adequate safeguards, basically the same provisions as in the GDPR. What should accountable data controllers and processors get prepared for? They should pay attention to the fact that Member States will be able to provide by law or by collective agreements for specific rules to ensure the protection of employees' rights and freedoms in the employment context. Those national legal provisions shall include suitable and specific measures to safeguard the data subject's human dignity, legitimate interests, and fundamental rights, such as transparency of processing, transfer, and monitoring systems. Member States should notify national legal provisions regarding employment processing to EU Commission. If it is authorized by Union or Member State law or by a collective agreement, the interdiction to process special categories of data shall not apply to processing necessary to meet the obligations and to exercise the specific rights of the controller or of a data subject in the field of employment. The question triggered now is, will Member States' law or collective agreements be framing the processing of personal data in the employment context regarding employees' consent in the same way?